You get rear-ended at a red light and suddenly your body becomes a courtroom exhibit. Your treating doctor says one thing, the insurance company's hired expert says another, and now everybody is staring at you like you are supposed to referee two guys in white coats. Here's the thing nobody tells you. Your treating physician actually saw you limp into the office, heard you groan when you sat down and watched your progress over weeks or months, while the retained expert usually meets you once for maybe 20 minutes before writing a report. That difference matters more than people realize. Courts and insurance adjusters often give extra weight to a treating doctor because they have what lawyers call a longitudinal relationship with the patient. Basically a fancy way of saying they actually know you beyond a single awkward exam. But retained experts are not just villains twirling mustaches. They're brought in because insurance companies want a second opinion that might poke holes in your claim. Kind of like when your friend tells you your outfit looks fine, but your other friend says absolutely not, go change. So when these two doctors disagree, a good accident injury lawyer does not panic, they investigate. They pull medical records, compare timelines, and check whether the retained expert even reviewed your full history or just skimmed a folder for 10 minutes before billing $400 an hour. Sometimes the conflict is really about bias hiding behind big words. If an expert works for the same insurance company over and over testifying almost exclusively for the defense, a sharp lawyer will bring that pattern up in front of a jury like revealing a plot twist in a mystery movie. On the flip side, sometimes the treating doctor is genuinely wrong or influenced by wanting to keep a patient happy. Lawyers know this too, so they cross-check objective evidence like imaging scans, lab results, and physical therapy notes instead of just trusting anyone's opinion at face value. Depositions become the real battlefield here. This is where lawyers ask both doctors detailed questions under oath, looking for inconsistencies, assumptions, or moments where an expert admits they never actually examined you in person. Juries are humans, not robots, so credibility matters just as much as data. A confident expert with fancy credentials can still lose the room if they seem detached, robotic, or like they are reading from a script written by the insurance company's legal team. This is why lawyers often bring in independent medical evaluations too. Basically a neutral third opinion nobody can easily accuse of picking sides. Think of it like calling in a substitute teacher to settle an argument between two kids who both think they are right. Documentation becomes your best friend in these situations. The more consistent your symptoms are across doctor visits, pharmacy records, and even your own text messages complaining to your mom, the harder it becomes for a retained expert to argue you are exaggerating. Timing also plays a sneaky role. If you waited 3 months after the crash to see a doctor, retained experts will absolutely use that gap to argue your injury came from something else, like that time you tried to skateboard down your driveway. Good lawyers prepare you for this before it even happens. They explain that showing up consistently to appointments and following medical advice is not just good for your health, it is basically building your own credibility file without you even realizing it. At the end of the day, this conflict is not really doctor versus doctor. It is truth versus doubt, and your lawyer's job is to make sure the version backed by real evidence is the one the jury actually believes. If any of this sounds like it could apply to your situation, do not just wing it alone against trained professionals. Do you want to learn more about how we help people handle exactly these kinds of cases? Check out our links in the description.